We begin tonight with the decision from the Michigan Court of Appeals that could set a new precedent for school shootings. We thank you so much for joining us here for 7 Action News at 6. I'm Carolyn Clifford.
And I'm Dave Llewellyn. Today, a 3-judge panel affirming that a jury can decide whether the shooting was a reasonably foreseeable outcome of the Crumbleys' alleged negligence.
This outcome has been a work in progress for some time now. In February of last year, a judge bound the parents over for trial, but their lawyers appealed that ruling. Then in November of last year, the Michigan Supreme Court issued a stay on the case and sent it back to the Court of Appeals.
7 Action News reporter Kim Russell is live at the Oakland County Courthouse tonight with a look at the decision. Kim.
I was at the Court of Appeals hearing earlier this month where judges heard arguments about whether James and Jennifer Crumbley should be charged with manslaughter for their son's actions killing classmates at Oxford High School. The judges spoke about how a decision could set new precedent with wide-reaching impact. Now, a bold decision sending the case closer to trial here at Oakland County Court. This Court of Appeals opinion says James and Jennifer Crumbley ignored clear signs their son intended to hurt someone. Just one example, this disturbing drawing depicting a gun like the one they bought him, the words "the thoughts won't stop," and a picture of someone injured. As a result, they should face trial here at the Oakland County Courthouse for 4 counts of manslaughter.
Why is it important that the parents face this trial? What does it mean to you and to others who you talk to?
It will set a guideline and a precedent that if it does happen again, that everyone accountable will be held accountable.
Jace McCarthy graduated from Oxford High last year and is relieved to hear the decision. She says her brother misses his friend, Justin Schilling, one of 4 students killed by the son of James and Jennifer Crumbley.
My brother will talk about him and like the stories that they shared. And it really sucks knowing that there's no chance of him like going to see him again. If he wants to talk to Justin, he has to go to his grave.
McCarthy says all parents need to know they have a part in preventing school violence and never-ending loss for so many.
It constantly lives with you. And, you know, the minute that you wake up, you remember it. The minute that you go to bed, you remember it. There's not like a second where you kind of forget what happens.
Prosecutors and the defense are subject to a gag order in this case because the judge was trying to minimize them playing the case out in the media, so they cannot comment at this time. But there is no question this decision is a blow to the defense. In Pontiac, Kim Russell, 7 Action News.
All right, thank you so much, Kim. Now joining us live to give us some insight on the legal process is Mark Chetkow. He was the lead federal prosecutor on the historic Kwame Kilpatrick corruption trial. Thank you so much for joining us tonight, Mark.
Glad to be here.
So first, if the courts are saying the parents had some insight into their son's planned actions, what does that really mean for the Crumbleys going forward in trial?
Well, the Court of Appeals was very careful in this case to say that they were not deciding guilt or innocence. They were simply saying that the district court did not abuse its discretion when it found that there was sufficient evidence, probable cause to bind the case over for trial. I mean, ultimately, it's going to be up to a trial jury that's going to hear all of the evidence, which the Court of Appeals admitted that it had not heard. And they will be hearing it by a higher standard beyond the reasonable doubt and subject to cross-examination by the defense.
How hard will it be for prosecutors to prove this at trial, that they knew what their son might have been planning to do at that high school?
It's going to be a very challenging case just by virtue of how novel and unprecedented it is. It's extremely rare for parents, if not unprecedented, for a parent to be held responsible for the crimes of their child. So the defense is going to emphasize that there was no way for them to have foreseen what he was going to do. Their son did not tell them of his plans. In fact, he hid them from them. By the same token, the prosecutors have some very compelling evidence in this case, which is why the Court of Appeals bound it over. There were all warning signs that he was going to do something terrible. His deteriorating mental state, his depression, hallucinations, his paranoia, his asks, his cries for help. Yet what did they do? They bought him a gun and then they failed to secure it. I think a particular note to the Court of Appeals and probably to the prosecution in its case is that the parents refused to take the son home when they were told by the school that he had threatening behavior and that they should get him some help, and yet they didn't do that. So under the very unique circumstances of this case, the prosecution has a good chance.
Yeah, a lot to go over. Thank you so much, Mark, for your legal expertise. We appreciate you. A lot of eyes will be on this trial. You can read more about the Court of Appeals decision right now on our website at WXYZ.com. Dave.